Hello, this is Dale Whitman, welcoming you to ProfDale's property video number 2. We're working on adverse possession, and the subject of this video is the conduct or behavior that an adverse possessor has to exhibit in order to successfully acquire title to the real estate. Now, we might begin our consideration of the behavior of an adverse possessor by asking the following question. Does every act of trespass begin adverse possession? Well, we already know that the answer to that is no. Not necessarily. The trespass has to satisfy a couple of requirements. First, it's got to continue for the right time period, such as 10 years or whatever the statute in the particular state requires. And second, it's got to be carried out in the right manner with the right behaviors. Otherwise, it simply won't count as adverse possession. So what are the elements of adverse possession? Well, there are traditionally 5 of them, and we're going to list them now, and then I'm going to show you how you can memorize them. The first one is that it's got to be open and notorious possession. Second, the possession has to be continuous. Third, it's got to be exclusive possession. Fourth, the possession must be actual. And finally, fifth, the possession has to be non-permissive. Often the courts will use the term hostile to describe this, but non-permissive is really a better way of capturing the concept, I think. Now, to remember the 5 elements of adverse possession is very easy. All you have to do is think of the word ocean, because the letters of the word ocean correspond to the first letter of each of the 5 elements of adverse possession. Let's take another look at them. Here they are. O is for open and notorious, C is for continuous, E is for exclusive, A for actual, and N for non-permissive. So you can use the word ocean to remind you of a checklist of the 5 elements of adverse possession. And if you're taking an examination and there's an adverse possession issue, I'd strongly recommend that you mention each of the 5 elements. Some of them may apply and some of them may not, but if you mention each of them, you're sure to get the ones that are important. What about the pirate? What does he have to do with adverse possession? Well, not very much, I'll admit, but in a sense, an adverse possessor is someone who steals land. So just as a pirate is a robber who takes away the booty, an adverse possessor takes away the land. So where do you find pirates? Well, on the ocean, of course. So if you think of the pirate stealing the land, it'll remind you to think of the ocean, and you have your checklist of the 5 elements of adverse possession. Now we're going to talk about each of the elements for a few minutes, and the first one is open and notorious. Well, the answer there is pretty obvious. It simply means that the adverse possessor's got to be where people can see him or her on the land. There's a very famous case, for example, where the adverse possessor was his activity was in a cave under the ground. And the court said that that doesn't count as open and notorious because people on the surface couldn't see the adverse possessor. In another case, a rather well-known New Jersey case, the adverse possessor built a stairway on the exterior of a house, and the stairway projected about 15 inches over onto the neighboring property. Well, the court looked at that and said, it's open, that is, people can see, if they know to look, that the stairway goes over the property line. But we don't think it's notorious because it's such a tiny trespass that people in the neighborhood, in fact, the next door neighbor, probably wouldn't notice the trespass on his property. So therefore, the court indicated there might be a slight difference between the word open and the word notorious. Now that decision is controversial. The New Jersey courts themselves have had a hard time deciding whether they want to continue to maintain that position. But it does suggest that there might be a slight difference between open and notorious. The second element is continuous, and of course continuous means as continuously as a normal owner would be in possession of the property. So that means that continuous doesn't have to be 24 hours a day, 365 days a year. For example, if it's residential property, the adverse possessor can take a reasonable vacation or holiday and be away from the property for a few weeks each year and would still be considered to be in continuous possession. Likewise, if the property is agricultural and it has a specific growing season, if an adverse possessor comes on the property and cultivates the land and grows some crops during that season, that's sufficient for it to be continuous possession. So in other words, we look at the type of property and say, how continuously would a typical owner be in possession of this property? And if the adverse possessor can approximately match that degree of continuity, the adverse possessor will satisfy the continuous requirement. The third element is exclusive, and exclusive means a couple of different things. First, it means that the true owner must not be in possession of the property. If you're an adverse possessor and you move on land when the true owner is there, obviously your possession is not exclusive and you can never get title by adverse possession. The word exclusive has another meaning as well. It means that there mustn't be competing adverse possessors. In other words, if you have two different adverse possessors trying to get the land at the same time, neither one of them will succeed. The picture of the houseboats is there to remind us of a good case to illustrate this point. It's a Washington state case in which a guy who owned a houseboat tied it up on a beach that didn't belong to him on Puget Sound. And he lived in the houseboat and walked across the beach, used it as access to his houseboat for more than 10 years, which was the statutory period in Washington. And then he claimed that he had acquired title to the beach by adverse possession. However, only about 100 yards away, there was another adverse possessor who had likewise tied up his houseboat to the beach. So both of them were trying to get the land at the same time, and the Washington State Court said quite correctly, neither one of them can get it. So if there are two or more competitors, none of them get title to the land. The fourth requirement is that the adverse possession must be actual. And what that means is the adverse possessors really got to go on the land and engage in some activity there. Now, the activity is perhaps potentially controversial. Largely, this overlaps with open and notorious, but how much activity must there be? Well, for example, is mowing the grass or maintaining the lawn sufficient? What about playing a game like volleyball or badminton? If you do that on a fairly regular basis, would that be actual possession? What about parking a car on the property, or gardening on it, or picnicking? What about disposing of trash? Now, I can't give you a definite answer to any of those because all of them have been considered to be adequate actual possession in some cases, and all of them individually have been rejected in other cases. What's more, you need to think about whether an adverse possessor might act like a landlord. If an adverse possessor rents out the property, admittedly they don't own it, but of course their tenant won't know that, and the tenant engages in some activity, will it count? Well, it sure will. The tenant's activity is attributable to the landlord. But whether the tenant's activity will be enough depends on what the tenant does, and the list above on the slide gives you an idea of some of the types of activities that might be questionable as to whether they're sufficient to be actual possession. Now, the final element of adverse possession is that it's got to be non-permissive. Often the courts, as I mentioned, will call this hostile, but don't take that literally. It doesn't mean that anybody is angry at anybody else or upset or has ill feelings toward anyone. Hostile simply means that the parties haven't given one another permission to occupy the land. It's not a state of mind. So whether the adverse possessor has permission to be on the land is critical to being a successful adverse possessor. If you have permission, you can't ever succeed. You might wonder about the case in which the adverse possessor starts out being non-permissive, and then after he or she has been there for a while, the true owner comes to the adverse possessor and gives them permission. Does that mean they can't succeed in their adverse possession claim? Well, the answer is it depends on whether the adverse possessor acknowledges or accepts or acquiesces in the permission. If they admit, in effect, that they're now there with permission, they've lost their adverse possession claim. But if they reject the permission and say, no, I don't have your permission, I don't want it, and I'm still hostile, then they can succeed in getting title by adverse possession. Now, there are some states that require additional elements to be a successful adverse possessor, and we're going to list a few of them. The first one, and without any doubt the most confusing, is the term claim of right. What does that mean? Well, in many states the meaning is unclear, or it may not really mean much of anything at all, except perhaps that you've got to act like an owner. In the other states, the claim of right term might refer to whether the adverse possessor is in good faith or bad faith, and we'll come back in a minute and talk about that issue. Some states do require payment of property taxes in order to be a successful adverse possessor. A few states require payment of taxes in all cases, and a few more states say that if you pay the taxes, that shortens the adverse possession time period. Likewise, if the adverse possessor has color of title, remember from our previous video, that's a piece of paper that looks like a conveyance of land to the adverse possessor, but it's invalid, it's defective in some way. Well, it doesn't give actual title to the adverse possessor, of course, but having color of title may shorten the time period that the adverse possessor has to remain on the property. Now, we need to wind up by talking a little about good faith and bad faith. Good faith is required in a few states, and it's understandable. We can say, well, after all, if an adverse possessor isn't in good faith, it seems sort of like a shame to reward them for sitting on somebody else's property. So we can see why a state might require good faith. On the other hand, there are a few states that require bad faith, that in effect say the adverse possessor must know that they're on somebody else's property. That's sometimes called the Maine doctrine because it originated in that state, although the Maine courts don't actually follow it anymore. The majority of states say neither good faith nor bad faith is relevant. The state of mind of the adverse possessor just doesn't matter. All that matters is that they have fulfilled the behavior requirements and that they've been on the land for the required time period. What do you think about whether a state ought to require good faith or bad faith? Well, there's an argument that it's a bad idea to require either one, and the reason is that they're subject to manipulation by the adverse possessor. For example, take a case in which an adverse possessor goes on the witness stand and is asked by his own lawyer, were you there in good faith or were you there in bad faith? Well, the chances are no one except the adverse possessor himself or herself knows the answer to that question. In all probability, they haven't made any statement about their good faith or bad faith to anybody else, and therefore it's easy for their lawyer to educate them about the legal requirements, and it's easy for them to basically lie about whether they were in good faith or bad faith in order to satisfy the state's requirement. So the better rule in all probability is the majority rule, that neither good faith nor bad faith is relevant to being a successful adverse possessor. That concludes video number 2. If you have questions or comments, email profdale01@gmail.com. We'll continue our discussion of adverse possession in video number 3.